on your Muniment title, your affidavit of airship, and now the small estate, I mean, we'll take care of that fee in most cases if I'm representing the cash buyer buying it. So I don't know if you are aware of that.
No, that's actually a very good service that you provide, because obviously, you want to limit the barriers to the transfer of property. Right now, as you know, the market's pretty hot. It's a seller's market. There's a lot of
Yeah,
buyers out there. The inventory is lower, right, than I've seen
right.
in quite some time.
Introduce yourself. Let's know who you are, Sal, because you're a great guy, all
Right.
around honorable family man, everything, and I love working with y'all's team. So
Well, thank you, David. My name is Sal Espino. I'm an attorney at law here in Fort Worth, Texas. I've been licensed since 1995, a graduate of TCU, BBA in accounting, and SMU Law School. I served on the Fort Worth City Council for 12 years, from May of 2005 through June of 2017. Since 2003, my wife and I have had a title company, presently operating under the name of Attorney Title Texas. In December, I decided to come back full time to the practice of law, and also to assist Liz with the title company. Before that, I was the director of government relations for Fort Worth and Tarrant County's transit agency, Trinity Metro, legally known as the Fort Worth Transportation Authority. But what I try to do, obviously, is assist in facilitating closings. And a lot of times we do have probate issues. Either someone dies without a will, or someone dies with a will, but they need a quick and fast way to prove up the will. And one of those ways is if you die with a will and you just have real property and there's no debts and you don't really need a formal probate administration, one of the ways you can do that is through a process known as muniment of title. Muniment is just a fancy word that means evidence of title. So let's say someone dies with a will, leaves the wife everything, and their main asset is just a house or real property. And there's no debts. There's really no need to do a formal probate where you have to appoint an executor and do formal administration. And so you can do an expedited process, also a cheaper process known as muniment of title. There's several requirements. Obviously, there has to be a valid last will and testament. That's requirement number one. There are no debts owed on the property, except you can have a debt like the mortgage on the house, right? There can be a lien securing the real estate. There's no need for a formal probate administration. There's no claim for Medicaid filed after March 1st, 2005. And of course, you have to present the will, within 4 years from the date of the decedent. This is usually not a problem. When someone dies, they immediately come to our office,
okay.
and they say, okay, probate the will. Then the other thing, of course, here in Fort Worth, Tarrant County, you have to show jurisdiction and venue. So the decedent has to have, of course, passed away or lived here in Fort Worth or in Tarrant County. And then the will itself doesn't name a state or a state agency or a charity as a beneficiary under the will. And of course, the will has not, you have to show hasn't been revoked. And that, if there is a spouse, that marriage was not dissolved after the will was made, or if there's children, there's not any additional children after the will was made. So it's a very simple process. The way you do it is you pay a filing fee. You file what's called an application to probate the will as muniment of title. And then there's notice given, to interested parties. And then within 30, now with COVID, it took a little bit longer. Within 30, 60 days, there's a hearing. And basically the beneficiary of the will or the executor of the will there's a witness. The attorney has to prove up the will, prove up these facts I just mentioned. And it's a 15, 20-minute hearing. It's been done by Zoom because of COVID this past year. And then after it's over, the witness signs a proof of death and other facts, and the court enters an order admitting the will as a muniment of title. So with the order in the will that's filed with the court, that's your chain of title. So with that, now you have a legal document that passes title without having to go through a whole probate process that could take months or up to a year to do. You've got it done, and you can then go sell the property, or you've established title in the beneficiary in the will.
Excellent. And now, can you represent people outside of Tarrant County, or do you prefer to keep it within your county?
No, we can do contiguous counties. This is a statewide process, so muniment of title is allowed under the Texas estate codes. So this is an easy way here in Texas. So it can be done, obviously, here in the North Texas area. It can be done in Dallas County, Parker County, Tarrant County, Dallas County, Denton, all of the contiguous counties here in the Metroplex.
One thing I find, Sal, is that this is not even mentioned to most people in probate. And most people that I find in the business when I go to list their property or to help them just sell it quickly is that they have one or two heirs. It's not that difficult. They do have a will, but it is never mentioned to them because it does circumvent it and it does save on the money spent. So kind of touch on that. Is there a reason why people want to charge so much for the probate process
Well,
in general?
I think there's a misperception that when you have a will, you have to go through a formal probate of a will. There's several different options. Even with a will, let's say you really don't have that much, and you may not even need muniment title. Most title companies accept what are called affidavits of heirship. Even if you have a will, and you may not necessarily need to probate the will, and that's even cheaper than a muniment of title. An affidavit of heirship, basically, it's allowed under the Texas Estate Code. Let's say you die, the person dies, and let's say it's pretty simple. They leave a wife as the surviving spouse. All of the children of the same marriage. Well, under Texas law, you need to do a muniment of title. You could just basically do an affidavit of heirship, and there you will need two witnesses that are disinterested that can speak about the family history, marital history, and obviously you describe the real property. And then most title companies do require the interested party to also sign the affidavit. And basically, it's someone that has knowledge of the family and marital history of the decedent. You list the property there in the affidavit, and then that's filed in the county where the property is located. And title companies will accept that as chain of title. Then the next step would be a deed from, let's say, the surviving spouse who wants to sell the property to a prospective buyer. So that's another way. That's called affidavits of heirship. And then another way to do it, let's say you also have other property besides real property. You can do what's called a small estate affidavit in order. It's a very small estate. You do file an affidavit and a proposed order with a probate court. And the reason you would do that instead of an affidavit of heirship or muniment of title is, let's say someone leaves a bank account and you as a surviving spouse were not put on that account. There's not a payable on death. You're not a joint person on that account. Some banks will not accept, obviously, affidavits of heirship, and you may not need to do a formal probate process, or you died without a will. You can do a small estate affidavit in order. And the small estate are those estates that I believe are pretty small. And then you basically do the same thing you do in affidavit of heirship. You have two witnesses that lay out the family and marital history. And as far as in counting what small estate, you do exempt your homestead and exempt property. And I believe any other property above that, I want to say, let me double check the law on how much property would constitute a small estate affidavit. And that's another, let me double check the law. I don't know if it's 50,000 or 75. I haven't done those here recently, but it's really, really a small estate. And
it's just a smaller number amount.
Yes, sir. Yes, sir. So those are some ways: affidavits of heirship, small estate affidavits, and muniment title. Yeah. So the decedent leaves less than 75,000 in property, not including homestead property and not included exempt property. So those are small estates, less than 75,000.
Okay. I know you can't talk about fees and stuff that exact, but in general, from a probate process to doing these items,
Yes.
How much are we saving in time, hassle, and actually money-wise, I guess you'd say?
Obviously, if you probate a full will and it goes through the whole probate process, it could take 6 months, 9 months. You may have to file an estate tax return. I mean, that could range a couple thousand, and depending on the complexity of the estate, it could be substantial, right? Muniment of title, since it's done so quickly, you're looking, in the range of $1,500 or so. Affidavits of heirship, depending on how complex those can range from $250 to $500. Small estate affidavits and orders, again, $1,000, $1,500. So you can see you go from a full probate of an independent administration of several thousand or even more if it's complex, to several hundred for an affidavit of heirship, to $1,000, $1,500 for a muniment of title. So you save substantially. And then the process itself, affidavits of heirship, if you do a closing, you could do an affidavit of heirship quickly and close. If it's a cash deal, fairly quickly after you get the title report and you clear everything, you could close in 30, 60 days on a deal, right? So you can quit. Now, muniment of title could take 30 days to 60 days, depending on how quickly you can get a hearing with the court and you serve the notice on the folks on the will.
And I've discussed with Elizabeth, and I've done this in the past, since I have a lot of clients that like to buy these properties as is in the condition that they're in, so that the family has that relief too, that we actually pay that fee for them on your Muniment of title, your affidavit of airship, and now the small estate. I mean, we'll take care of that fee in most cases if I'm representing the cash buyer buying it. So I don't know if you are aware of that.
No, that's actually a very good service that you provide, because obviously, you want to limit the barriers to the transfer of property. Right now, as you know, the market's pretty hot. It's a seller's market. There's a lot of buyers out there. The inventory is lower, right, than I've seen in quite some time. And so you put a property on the market, people are snatching them up, and then obviously a lot of times you have these airship issues. Someone either dies without a will, so you got to clear the title there, or someone dies with a will, but then you've got to obviously prove up the will. That's what's called probate. And I just indicated the different ways you could do that. That could be economical, efficient, and fast.
That's awesome. Yeah, and again too, if we just list the property as a brokerage, we'll actually pay the fees as well. So I just want to get that clear. So it helps everybody out, and I'm glad you guys work with me on that, because we could get people in, and they don't have to come up with all the fees and start a bank account, pay the taxes. It's just, I've seen probates. I've got one that was just completed, 28 heirs. It was a mess. Took almost 4 years. So that's a little messier. But if they have a cleaner result or lesser heirs and they have that will, I mean, totally, we recommend this option for them.
Right. And the options I indicate are pretty simple situations. If it's complex, let's say, like you said, you have a lot of heirs and the person dies without a will, sometimes you have to do what's called an heirship proceeding, which is a formal proceeding in probate court to establish who the heirs are. That's the heirship proceeding. And obviously, if there is a will and it's a complex estate, complex situation, or there's a will contest, and that may take time, because basically in a will contest, folks are contesting the validity of the will. And under Texas law, that's why I say, if you have a will, make sure you comply with all the formalities under Texas law. Usually you want to have two witnesses, witness the signing of the will, and the will has to have what's called a self-proving affidavit, because that's as good as life testimony in court. Most situations are pretty simple. So you can do a lot of the simplified methods I just outlined. You could do a muniment of title, you could do an affidavit of airship, or you could do a small estate affidavit. Now, obviously, if it's a larger estate or a more complex situation, then you have to go through the whole formal probate of a will and have what they call independent administration. There's also something called dependent administration, but those, in my experience, those are for more complex situations and larger estates.
So how do what's your address, where you're located, and how do we get a hold of you if they have questions for you?
You can reach us at the law office of Sal Espino in Trinity Title, Texas, North Fort Worth, at 1205 North Main Street, Fort Worth, Texas, 76164. We're located conveniently near the intersection of North Main and Northside Drive, 5 minutes from the stockyards, 5 minutes from downtown, 5 minutes from I-35. Our phone number here is 817-624-3352. And my legal office email is espino, ESPINO _law at sbcglobal.net. So those are the different ways you can reach out to us. And obviously, you can always reach out to our title company and call our title company. We'd be happy to make an appointment to discuss how we may be able to assist you in either proving up a will, or help you with an heirship issue, or help you with your closing.